All right, all set. Okay, so now we are finally into module 4 for the CIRS, and this is going to talk a little bit about the internet law and issues of ethics in internet or expectation of following certain standards or ethical concerns when we do our research work. So that's what we're going to cover. Generally, we just sort of review different areas of the law, but we are specific about certain um, concerns that might directly or indirectly impact your research work or researchers. Okay, so let's get an overview. Something we need to get familiarized with. Um, Legal issues in emerging internet technology. This is the heading, and in this one, these are bullet points just to give you an idea of what gets covered, something that might directly or indirectly impact our work as researchers. There are legal issues of internet security. Of course, you have to maintain the integrity of data, some of the information that you keep. You need to follow certain process procedures to ensure that it doesn't get leaked out or whatever else that you need to apply to secure the data. Challenges in mobile laws, there is an issue of jurisdiction because this is a movable property that you keep moving around with the uh, internet devices, let's call it. And, things that happen, your interaction with others outside in the internet works that might result in some sort of litigation and where you have to establish or the court has to establish jurisdictions. And then we learn what are the different types of jurisdictions. Cloud computing, there are agreements, there are, different types of agreements. Some are called, it's called click wrap agreements. Then you have others also. Plus, there are issues of intellectual property such as copyrights and trademarks, etc. In cloud computing, you're basically using somebody's softwares or you are um, kind of working on a timeshare basis also. So there are these legal issues that may start to emerge. Um, Legal issues of social media platform, of course, it is more to do with privacy, sharing of information. Then you've got things like reputation management, um, that might l- result in libel or slander. So those are the different laws of tort that gets into action. You've got laws of spamming, ransomware, cyber vandalism. Of course, those are pointing more towards the criminality of situations and it's less of a civil matter and it goes as deep as criminal offenses. You've got online speech, media laws, cyberbullying, anything that may have a mix of morality involved as well as how the social setup dictates um, how and what you can have access to share information and so on. Cyber stalking and cyber laundering, money laundering, bitcoins, etc. E-commerce consumer protection law, that's when you have a situation where you are dealing with like five different sort of agreements just on one website, to what extent you are protected. um, Online surveillance, fake videos, false news, more on the online investigation backgrounds, um, digging in deep to find evidences and so on. um, Challenges of data collection and its use, crimes committed via dark website. Anyway, this part we are not very much interested in, proxies and anonymity and so on. So this is just an overview. It's not like individually we're going to cover everything, but we are just talking generally the different sort of situation scenarios that we might somewhat be able to find a connection in collection and using of information, as well as a distribution of information, and where the privacy and other aspects of the laws generally would apply that might impact your research work. Then we've got legal issues in internet affecting online researchers. Internet jurisdiction is one, internet privacy, internet IP. IP here, it's not like a computer IP, it's intellectual property. Then you've got digital evidence collection, deep fakes, AI responsibility. AI is an emerging thing, and so is the what we call the mm, the machine learning or artificial intelligence that is playing a large role in um, you know building up reports, gathering information in an automated process. So there is an element of bias, of course, and there is an element of responsibility for the information integrity that you have to be responsible for. You got information and data confidentiality. There is an element of slander and libel. Slander and libel is when you are defaming, it's part of the defamation laws. And we'll look at that also. And then public opinion, and public opinion matters. So taking the responsibility of making a judgment based on some rationale instead of having any bias or any reason for you to go against public policies, generally speaking, and where certain research work may impact adversely to issues which may be sensitive to a large segment of public, and so on. Areas in internet. So the laws will be dealing with intellectual property, online privacy, e-commerce, electronic contracts, online liabilities, defamation, and internet crimes. Starting with establishing legal jurisdiction. In the internet, there is the line of what is construed or considered um, legally liable or cause for filing a claim may have its origin in what it could be considered jurisdiction of going after or filing for any kind of legal claims. So, jurisdiction obviously is a matter that you as a researcher may not know of as much, but if you go to the court, you will find out very quickly if certain matters can be contested in that jurisdiction or not. And that's where we are going to look at the different types of jurisdiction in general sense. There is something called personal jurisdiction. There is general jurisdiction, specific, subject matter, and territorial. So, what is personal jurisdiction? Personal jurisdiction, I cannot give you the exact definition because I don't have a memory for that, but I can tell you what it is, generally speaking, with how the legal system would look at the personal jurisdiction over matters that could be contested as from the plaintiff side, and at the same time from the defense perspective, or whoever is the defendant will also have to ensure that whoever is suing them or going after, or where some legal matter is contested, whether they can exercise the jurisdiction to or not exercise, or may not have jurisdiction over the matter in where the defendant is residing, or where the defendant has a permanent place as having its what we call the it has, well, let's just call it has the residence for now. Okay. Residence could mean different things. Residence can also mean, and we are talking about the defendant side, It also means that whoever is being sued has enough interest or has matters that are dealt with on regular basis for that defendant in that area or specific geographic location. So we would be calling it as having a minimum contact law or minimum contact test that needs to be proven by the plaintiff for for it to have the court accept that claim uh, based on the personal jurisdiction, and that personal jurisdiction for the defendant would depend on the minimum contact test with that location. So I've repeated it. My apologies for that, but that's what I'm trying to say. And for that reason, the personal jurisdiction from the court's perspective or from the side of the court system, they would have a personal jurisdiction to call upon or have someone be uh, called uh, to do the litigation in the jurisdiction of that court system. So if a personal jurisdiction is established for someone who is actually outside of the province or outside of the state, um, and residing somewhere else, the plaintiff would ask the court to see if they have a personal jurisdiction over an individual to be called into that court of law where the actual claim is being filed. So that way, the court will have a personal jurisdiction over that individual or over the defendant. Then we've got general jurisdiction. General jurisdiction means that the court at times would have jurisdiction that, depending on, again, the minimum contact test, would have a jurisdiction for different types of litigations, including bankruptcy, family law related, contract law related, torts related, or criminal offense. Would depend on whether or not the court has a general jurisdiction to entertain such matters all in one, and it happens in smaller counties or smaller cities where the court may have general jurisdiction because they may not have the different courts in action, or it may not have such an elaborate established court system. So they would have a general jurisdiction. Then there is a specific or limited jurisdiction, meaning that it depending on what type of offense is actually being contested. Both plaintiff and the defendant would have to go to a specific court. For example, um, if it is a matter of filing bankruptcy or account receivable collection matter, um, or to get a stay order on rental issues, or something to do with divorce or child support, they would go to specific court within the system of how the courts are set. I don't know, USA and Canada I can talk about, but generally these are specialized court. Like bankruptcy court is separate. The family law court deals with divorce and child support matters. And then, there are also city courts for smaller matters or matters that are dealt by the magistrates and not as a full court, which we would consider as a high court or superior court, Supreme Court, as in Canada. And in USA, there is a state, I think there is a state court, which is, I don't know what it is named. I think it's a high court. And then there is jurisdiction of a province, which we call provincial court, or a state court versus federal court, which is different. It deals with different laws. Um, and the provincial court system deals with other kinds of laws. So federal court usually deals with things like intellectual property. that falls under federal laws, international issues, immigration related, foreigners related, something like that falls into the federal jurisdiction. And that's talking about US. In our justice system, we also have federal courts, which is similar to US federal courts. And again, the type of laws or the type of claims that you can file will have to be specific to a certain type of issues. And the provincial, on the other hand, has more of a has a more detailed kind of or more specific limited jurisdiction courts. So that is what it means when we say specific limited jurisdiction. Then you've got subject matter jurisdiction. It is also specialized in how the court system would look at matters that has to do with civil laws versus criminal laws. If it is a criminal issue, then you will have to, you will be looking at a different way of how the laws are separate from from the civil liabilities. Civil liabilities are less harsh generally. Criminal are more harsh, and basically they are got a jurisdiction which is depending on what matter you're contesting. At times, it could be a civil law and the criminal law together, or could be partially criminal and partially civil. Then you've got a territorial jurisdiction, which means that it is usually the jurisdiction that is controlled by the federal law, or the federal law governs the legal system in those territories, such as I believe Puerto Rico, or then when you USA have territories besides the 52 states it has, and those territories are independent in the sense that they have their own laws, but the federal law stands superior, and it is actually the authority of the country like US to establish its rule in territories of that country. I think Puerto Rico is one. There is I don't know. There is other territories of US also. Um, Justin, you might know some. Can you tell me what are the other possible territories in US for USA to have a control over that? Let's see.
I mean, you have your district courts, you have your federal courts, um, but I'm not
No,
aware of any sort of territory.
all right.
Or,
So
you just have
USA territories.
you just have states, district, um, and federal.
Guam is one. Puerto Rico is one. US
Oh,
Virgin
oh,
Islands is one.
yeah.
Okay. These
There's
are
no.
the territories. Uh, 12 US, you've got 12 USA territories. So that are actually, as you have like state laws in the federal territories, they have their own laws, which we cannot say that they could be state laws because they are territories. And those laws are actually local, or there is a local jurisdiction at the level where you have given you've given that the US laws are more complacent, and local laws may remain intact. However, the federal laws would prevail, and federal authority is extended, or you could say that it has a jurisdiction which controls the local laws or the territory laws that are there already, which we cannot equate exactly as we do in state legal system in USA. So if you are in, let's say, Puerto Rico, you will find some surprises on consumer rights, for instance, or marriage laws divorce laws. They might be different. People intentionally go there and do their marriages sometimes, for various reasons. And there would be other benefits also, like taxation laws, for instance, in these territories are different. But like I said, the federal laws prevail, and that has more of a authority over, or they could actually impose uh, the federal law over the local laws. Yeah. So that's territorial laws. Uh, Territorial jurisdiction refers to jurisdiction over cases arising in or involving person residing with a defined territory. Okay. Now, the court's authority to determine the jurisdiction. This is important because if it's something to do with, obtaining information or doing some research work, and while it's going on, there might be issues between you and the client, and you could say that you could if you take your position as a defendant, and somebody else or one of your clients is in dispute, and there needs to be somewhat the situation where everything is happening electronically over the internet. Then there could be matters which would require for the court system to exercise its jurisdiction or its authority or even personal authority over who has sued you, or if you are the one who is the defendant, then for you to determine whether or not that individual or that client of yours has the authority to go after you, um, in wherever you needed to, or wherever they're filing their lawsuit. So jurisdiction is important. Here it is saying court's authority to determine jurisdiction, whether the court has the authority over the subject matter, whether the court has authority over the parties before the court, personal jurisdiction. So, fundamental cause of um, pursuing or filing something, or even your claim to be accepted somewhere, the court is going to figure out if it has the subject matter jurisdiction, first of all, like uh, what type of law, if it is civil litigation or something to do with intellectual property, if they have the jurisdiction or not, will be ascertained. And then if that is not possible, or if the situation is kind of complicated from the subject situation, it can actually fall back on something called personal jurisdiction. Personal jurisdiction usually is more important in based on the gravity of situation or the gravity of offense, and where the court feels that whoever is the aggrieved party has a cause to go after somebody that may have caused the harm in their own jurisdiction, and has moved from there, or has just visited and caused that harm, and then left the geographical um, area, or that particular location, from one state to another, for example. So the court would ascertain if they have a personal jurisdiction or not. So there is a lot of uh, kind of if it is to do with the internet, or something that has happened as a consequence of a relationship established on the internet, in whatever dimension it might be a social media related, e-commerce, or whatever it might be. The court will be looking at whether or not it has personal jurisdiction over whoever the defendant is. And if that is the case, then the other aspect from the defendant's point of view is that if the court has established that they had the personal jurisdiction over that individual, then that person will have to be mm, physically be present in the court which has determined the personal jurisdiction over that individual. So there is this traveling involved, or there is a proxy or someone who would be representing that defendant if the court has determined that if they have a personal jurisdiction. And in order to get the personal jurisdiction established, which is more technical than the first one, which is subject matter jurisdiction, that's very common and it's not as difficult. But personal jurisdiction will also mean that the court has to um, be able to determine if they have done what they call a minimum contact test in this matter. So, what is minimum contact test? That is the question. A minimum contact test is actually embedded in the spirit of it is actually determined through what we call a state's long arm statute. The state's long arm, this is purely US related. So here we are using state's long arm statute, and it is similar to what we have in Canada also. State's long arm means that it can establish not only jurisdiction, but a personal jurisdiction over the defendant if they meet the minimum contact test. Minimum contact means that that individual who's being sued, or who we can call a defendant in this case, the plaintiff would want the court to, or plaintiff would have to prove to the court that that individual caused the harm in that state, and that that individual is no longer present in that state, or it has other contacts in that state based on the frequency of the travel. If that individual had a business in that state, or if it has a relationship like ex-wife might be living there, or the children might be living there, or the nature of the offense is such as to give criminality to the offense that would increase the power or increase the minimum contact test as having the jurisdiction commonly less applied if it is a civil litigation, but if it's criminality, then they have a larger, um, uh, they have a larger jurisdiction that they can look for, uh, make it a cause for take for calling or looking for that individual, or sending out, let's say, things like subpoenas, or warrants and things of that nature. So but assuming if it is a civil liability, then as I said, the minimum context could mean how much of a relationship or a contact that individual has in that state. um, and therefore it could meet the requirements of a minimum contact test, and the defendant can easily look for filing and be accepted to file the claim in that court, even if that defendant, or where the plaintiff is asking for the defendant to be present in that present court because of the nature of offense and what may have met the minimum contact test. So that's the state's long arm statute. Same thing happens in a virtual world. The problem is that our legal system, both in USA and Canada, the judges are not as comfortable with you know the the technology aspect of how one can establish the uh, the level of grievance. the onus um, um, onus of establishing the extent of damage, as well as the moving parts the technology has that makes it even more difficult. Like if it is a cloud computing situation and it has to do with downloading something software, then wherever that server is sitting, or whoever is the owner of that server that is uh, you know um, sending out that information, that could be a jurisdiction also, or where the company is established that owns those websites, that could be another location. And the laws might be different, so the jurisdiction becomes more blurry. So this is a common situation when we are looking at long arm statute applied in a virtual situation, in a virtual world. Um, what can be considered as, let's say, a subject matter jurisdiction would be laws like collection of information through subjects that you are identifying as your sample, which are human beings, individuals, um, who need to give what we call informed consent before you can start collecting information. So that kind of legal system sort of stays intact, and irrespective of minimum contact test, those laws would apply uniformly all over the United States. So there is this part, and then there is a jurisdiction part. And because of the different jurisdiction based on the geographic location of how the internet has spread the communication, um, the the minimum contact test sometimes is the only way that the judge or whoever is filing for as a plaintiff would have to figure it out in the first place, whether or not one can be sued in that particular jurisdiction. Um, then we've got another test which we called, based on sometimes the jurisdiction established, and I'm talking about internet world right now and specific to the kind of website that you are interacting with. So if it is a personal jurisdiction and there is a test which goes beyond the minimum contact test, is the nature of the website itself, and how you determine whether certain website has caused uh, a level of damage, or where the onus of filing a claim that needs to be quantified in terms of punitive damages and actual damages um, may become complicated. So the sliding scale is what establishes that onus, or that liability, or that sort of damages that the court can actually work out for the aggrieved party. Like commercial websites. Commercial website has a higher level of responsibility and liability from the vendor's perspective, and from the user's perspective, they would be able to claim much larger damages because of the way that it is set, and there are, um, transactions, actual money flowing through it. So the commercial website would have a higher points in on the sliding scale, or higher weightage for filing for damages. Um, and then you've got other websites we call passive websites. Passive websites would have the least element of risk, and therefore less interaction with the outsiders. It is more of a passive site is just information pages. It is not interactive in any way. Like you don't do any searches as a third party. You don't interact in any way with how third party or any platform that otherwise would allow for activities on that web pages. That is not actually the way passive sites are set. Passive sites are just information site. So there is a less of damages there. I mean, there could be false or misinformation, false representation, and so on. But on the sliding scale, it is probably the least of it has the least cause of damages for the plaintiff to file for. Then you've got active website. Active means that there is a dynamic code running besides just the HTML, which is a static code, just showing the information. The active website may have small activities like registering, for instance, with your first and the last name, searching something. So it becomes active website. And when I say active, again, between active and passive, active means it would allow a certain level of activity by third party who is visiting it. Um, but it's a very it's a far less activity than commercial website. So on the sliding scale, less of a chances of liability and less risk for the vendors and for the plaintiff in case of filing anything against someone. The damages might be less than the passive side. Then you've got interactive websites. Interactive includes social media websites also, where it is providing a platform, a forum, or where third parties can interact and use it as their playground or a ground where they can interact with each other. But it would take a second place to commercial website as far as the damages or the liability or the risk of um, liability is concerned. So I could say that commercial website has the highest level of liability, interactive, the second highest, third is active, and the least is passive websites. So the legal system looks at the websites first as to their nature, and then it has a way of figuring out uh, what could be the level of damages or how far a plaintiff can file a claim in the court system. Okay. So let's take a break for now, Justin. I'll just give it 10 minutes
Okay, sounds good.
and I'll see you in a little bit. Eh?
All right.
Thank you. Hello, Justin, I'm back.
Okay.
Let me
Uh,
know. Okay, there. Um, now, I just want to talk about intellectual property a little bit, especially copyrights and trademarks. These are the two areas where, as a researcher who is using gathered information from different places, they would have to be concerned about, not to violate anyone's copyrights or trademarks. So we'll get an overview of what a copyright means and what is the difference between copyrights and trademarks. So the copyright law primarily protects original expression, which means that anyone who has actually created something on their own, which could be considered as individually different, and it's not a copy or it is a work which is unique, uh, that could be considered copyrightable, or it is basically protected under the copyright laws. Um, Such as novels, a writer writing something, even articles, anything that you put. And the moment you have written something and here or built some added information on top of the existing information, that also makes it copyrightable, right? Um, so paintings, photographs, sculptures, etc., which is an artwork that you create, it's all copyrightable. Compared to trademark has more a commercial side to it. It is more to do with a uniqueness that in the eyes of consumer is well recognized, or it has a value created in terms of goodwill, that is trademark or trademarkable. And even artwork, certain type of logos, they're also considered trademarks. Those we can also call them design marks. They're fall under the trademarks laws. Patents is something that is an invention, something new created uh, with the uniqueness that it is not comparable with anything even similar, because of its uniqueness. That would mean that you might be entitled to filing for patents for that invention. Right? So not much that we can violate as a researcher when it comes to patents, but trademarks and copyrights would be something that we have to deal with off and on. And I don't know if you know that trademarks also include word marks, which does not have to be a design of any sort, but it could be a statement that could be well known. Nike has a slogan, just do it, for instance, that is also trademarkable. And at times, without knowing, you may be using some titles or something that can be contested by someone as a violation of their trademarks because it's a trade name or a trade logo, and you wouldn't know about it until you get a letter from the legal firms. So that kind of makes us more aware of what can be construed as trademark. And there is an international database of trademarks that you can readily subscribe to, or even as a public, uh, for public interest, they've opened that database for anyone to look for similar wordings to figure out if it's been trademarked or not. So you can access that database. Copyrights you can protect in so many different ways, but legally speaking, any time that you can prove that it has been produced individually by you or by whoever is the one who is the creator, would have to just ensure that they have the ability to date or timestamp something, or put that in that work in the domain of third party to obtain that credibility for expressing it to be copyrightable because it was originally produced by you and it has been put in the custody of someone that does not have a direct relationship with you. So there are repositories and there are third-party platforms that would allow you to put those copyrightable work there with the date and a timestamp connected to you directly. So anyway, the copyrights include the right to reproduce the work. You can reproduce it, nobody else. You can make derivative work from it, or if somebody else wants to add to what you have produced and use it as information only, you will probably have to give a special permission to someone to create derivative work on top of what you have produced. But you have the right for derivative work, basically. You have the right to distribution, the public display right, the public performance right. So these are just some of the statements which are frequently used in the um, laws or the clauses that are uh, part of the uh, part of the law that is promulgated in copyrights and owners' rights. Then there is a question of copyright infringement. Could be three different types of copyright infringements. One we call direct infringements, contributory infringement, vicarious liability. Um, in terms of what is considered as a cause for the highest liability or where one can sue for a large sums of money is through direct infringement if they can prove that, or if there is a vicarious liability situation, then the liability is far less. And we will learn between these three: direct, contributory, and vicarious. So, direct infringement is outright copying somebody's work or distributing somebody's work uh, and without permission. And contributory infringement is where there is an infringement of copyrights, but it is done by one individual who has full knowledge that they are doing some infringement, but it is not directly infringing the word, the copyrightable word, with the knowledge of the actual owner of that work. So that is what we call contributory infringement. Okay. Here, the infringer is somebody that has done some sort of copyright infringement without knowledge of the original owner of that infringement. Okay, so that's contributory. They're contributing to infringement. Then there is vicarious liability. In this situation, there are more than a few people involved where the trail would somehow lead uh, to an infringer that did not have a direct knowledge if they are infringing somebody's work, and even those that passed on the work also don't have enough knowledge about or whether or not they're infringing somebody's work. So the chain is such that the liability is not as high because they are not able to verify if they're infringing something, yet unknowingly they were doing it without taking responsibility for verification or actually verifying somebody's work, and there would be more than a few parties involved. So that is vicarious liability. And that liability is, as I said, is far less than the direct infringement liability that one can claim. So these are three different ones. Then we've got internet related infringements. One we call piracy, which is actually direct infringement of somebody's work with the full knowledge that somebody is copying another party's work without their knowledge and without their consent. There is caching, which is somewhat a gray area to be considered as internet related infringement because caching from the technology point of view, it is just temporary placement of somebody's web pages, which can be called later on as information sets that are temporarily given a place as in indexing of web pages, for instance, by Google. So to say that Google is pirating or is actually infringing on somebody's copyrights because it has got pages collected for future use by third party or someone that have access to those pages, or it's been given access to those pages, and those pages are temporarily placed. That is called caching. So to say that a caching technology itself can be an infringement, it is a very difficult thing to actually pinpoint uh, uh, from the technology perspective, because Google had several lawsuits earlier, way back, I'd say, in the initial stages, and eventually the verdict came, and the legal system gave a verdict in favor of Google, saying that because it's a technology and it benefits both parties who is exposing those pages, first of all, and then to for them to get a benefit of being looked at or intentionally being put in the public domain, it cannot be considered as caching when it is collected by Google. So this is where there is a demarcation. However, the caching does come under some protection of the law, and depending on how it is used, whether it's coming from public domain or it is private information with a value attached to it, or there is a privacy issue, yet that information is taken out and collected and placed somewhere for future use, then it could be a caching infringement. Then we come to page linking, which is when the websites simulate and makes you think that whatever is presented on it is called from their own servers as their own individual private work that is exposed on those pages. Then obviously it is intellectual property. But if somehow the presentation is such that the information is actually pointing to the content, could be anything, could be multimedia content, images, etc. As long as there is a way of bringing that information onto your website, or your web pages are displaying it with your domain name exposed on the address bar, that could result in infringement, which we call linking of pages, meaning that, and there are different ways in which those links are established. There is deep linking, which means that the HTML pages might have a code that is copied for somebody else for SEO reasons or for competitors work that is copied exactly, that is deep linking. Then you've got inline linking, meaning that your website is pointing to something which actually is being fetched through the technology to appear on your page as if it is generated from within. But the fact is, when you click on that link, you will see that it is leading to another domain or another page. That's inline linking. Then we've got framing. Framing is when you are actually designing a space within your content page that looks as if it is a frame which is generating something from within, yet it is displaying the content that is running or it is live somewhere else, and it is temporarily just showing within that frame. Framing is technology which basically creates a demarcation or a box within which you can play somebody else's content. Example is YouTube, for instance. If YouTube is being displayed, or any video that is being displayed within the square box, uh, which we call frame, and the frame simulates as if, with the colors and the surrounding area, to make someone think that it is actually a design of the website, and whatever is displaying inside of it is originally belongs to that website. And that's why the frames are designed. So that is a kind of piracy also. Linking to infringing work means that you are linking something from your website to another website that already has infringed work, or has piracy related element or content on their website, and you are linking to that illegal website. That is linking to infringing work. So these are the linking issues which are considered IP or intellectual property infringing, particularly related to copyright infringement. Copyrights have different licenses. If it is a work that is displayed in the public domain, it has different types of established clauses and certain licenses or contracts, which are what has boundaries to um, public work to be used in a certain way. So if you look at the clauses, you can see that there is one clause that's called fair use clause, that might have a writing, or might have something as a statement which is different from GNU licensing clauses versus Creative Commons. These are all copyright licensing bodies which allow for certain licenses to give a blanket coverage for that public work to be used in a certain way. So there is a restriction of using it, but at the same time, these public licenses also allow for others to use the work, but again, within the confines of certain restrictions. So these three are the common ones. Then we are going to look at trademarks. Trademarks are different. The trademarks infringement, like as I mentioned, happens because there could be two different ways of how the trademarks are differentiated. One is word mark, the other one is a design mark. But whatever the different types may be, they are contested in the court of law based on certain attributes or certain ways of how individually they're considered as infringement, because there is a similarity in overall expression created. Similarity, of course, that's common sense. Similarity of goods and services, meaning that when you are filing for the trademarks, you are asked to give a certain classification to those goods under which those goods and services are branded. Those classifications are given numbers, like 42 is for certain type of goods, 44 is for certain other types of goods. So those numbering matters. So similarities are now considered as having the same codes or the same classifications. The system that is actually called NICE classification system is one of the systems that would put certain or give criteria to at the time of filing to the goods and services you are you know applying for the trademarks. The strength of plaintiff's mark. Strength could mean few things. One is that how long that mark has been there, or to what extent the consumer has faith and believe in those marks, or how much of the product is being sold over the past many years, and so on and so forth. The strength of plaintiff's mark is generally referring to the logo or the slogan. Okay. So that is the strength of it. Any evidence of actual confusion by consumers. If somebody comes to my website thinking that it is a product which is actually branded or have the value for the vendor, yet the consumer, instead of going to the actual vendor, is comes to my website and finds similar product, that would have caused a confusion in the eyes of consumers. So the evidence of actual confusion has to be there, that it is so much similar that the consumers may get confused and may end up on your web pages or buy your product instead of somebody else's. That evidence you have to provide. The intent of the defendant in adopting its mark. So if there is malice or malafide of intention, which is the crux of all the laws that come into play, and that is where the strength of the case relies, depends on, there has to be some way of establishing that it was intentionally placed somewhere for sale, and I'm assuming it's goods, not services for now. I suppose it's these goods, and it is the intention of whoever is selling it to get higher profit by selling something that is similar, but or maybe the same, and it is a direct infringement, or it is a copy, and it is compromising the quality of the product, and the goodwill of that product is intentionally harmed by diluting or diffusing the value of the goodwill for that item, because it is not up to the standards of a genuine product. So that is the intent that needs to be established. The physical proximity of goods in the retail place market. So physical proximity means here that you have to also establish the fact that it is a product that is not like services, for example, that needs to be better understood, but rather goods that can be identified with how it looks and appears in the shelves. That is the visual of it, and which is what it is referring to. But let's suppose if it is a CIRS course, then the user would have enough information on the website to make a knowledgeable decision, and it would not cause confusion of any sort. So that is what is important. And if it is a retail box of something, a physical product in the shelf, and it can be confused with another product of similar design or value, then there could be a matter of proximity to the consumer in figuring out if they can make the difference or not. The degree of care likely to be exercised by the consumer. This is actually, again, mixing it with the same statement as I said. If the goods are such or the services are such that a common consumer would not make a mistake because of the level of information that is there, because of the nature of the goods, or the proximity of the goods to the consumer, they are able to make that difference, or create or make that differentiation. That is also going to be considered when you are filing for infringement. The likelihood of expansion of the products lines, if it is something that the product would um, have impact on the overall goodwill of it, um, and and then it is harming the business of the actual trademark owner, because of the volume that you are presenting in the market, or it is to do with how it is impacting the overall market. So this is what it means, the likelihood of expansion of the product line. If the sales of the competitor or whoever is the plaintiff is reducing because of these causing consumer to in the eyes of the market, and the market is shifting towards the defendant's product, then that could be another reason for filing for trademark infringement. Okay. Let's just look at the actual database, international database. I think I can do that. That should be interesting to look up. Um, So when it comes to trademarks, we go to a database. It's called WIPO database. Global brand database. If you go on this one, what you end up looking at, let's suppose we want to check the brand certified internet. You can see that we have a trademark here, okay, that we had filed for. And if I click on this, so if anybody else is using CIRS, Certified Internet Research Specialist, search error, why? So just CIRS, just take CIRS. So you can see that these are design marks, right? Where you can see the designs, and there could be others uh, that don't have a design mark, like this one, for instance. Um, for this logo, CIRS, the owner is named here. And the good thing about the centralized database is that even if, because you see the intellectual property offices in different countries are regulated differently, but there is a kind of a communication between all the different intellectual property offices. Even if you file it in USA or Canada or Switzerland or anywhere else, it's all going to end up in the WIPO database. That's what it makes it centralized. So here you could see that this is filed in USA, this is filed in Switzerland, you know, and these numbers that you see down here, 42, 45, they stand for classification of the product. We call it NICE classification. And you can actually check what 42 stands for, and this is filed in Canada by University of British Columbia, and these are the different classification. But the design mark, and let me just look at the more famous ones like Nike, for example. See, this is the design mark right here, and there could be word marks also. I'm just trying to look for a word mark, and this is coming from Japan. Korea, Japan. And there are two conditions where one can use or apply a certain logo mark, or where you've seen TM. TM stands for the trademark that is being filed, or it's is under consideration. But the moment you see a circle and in between you see the R, that means it is registered or it is an approved trademark. See, like right here, pending means that they can put with the, and this is a word mark, Nike Infinitarian, and they can put the TM over here, okay, which means that it's trademark pending. But if it is a trademark that is approved, which is where you'll see the word like registered over here, you can put the R in there. Okay. And this gives a lot of value to those that have filed for trademark if it is to be contested in the court of law. Second advantage is that there are businesses that have not yet filed for the trademarks, or they have not even applied for it, but their product have been around in the market for a long time, and the litmus test of it to be contested against the trademark, or where they have to file for infringement of trademark when the trademark is actually been, let's say, filed by a third party, yet it is in the pending stages, it is not approved yet. And on the other hand, this individual who has been selling the product under a say, similar brand has a way of contesting it, even if they have not filed for it, on the grounds that their product has been around in the market for a longer period of time. And in the eyes of the consumer, there could be a confusion, even if the trademark goods or trademark logo or design mark is similar, yet the one that and that yet the individual that has not filed for it can still contest it in the court of law, based on, as I told you, so consumers, uh, as long as it is not causing consumer in the and it is of value, or it has established its own goodwill over a period of time, and there were X amount of sales already done, and therefore the product is spread across to different consumers already. So that is very important. And then the similarity of what classification it has been given. So if the classification 41, 42, and 44 is similar to someone who also has filed for something similar, it doesn't have to be exactly the same. And one can say that since it is not exactly the same, so there is this differentiator because of this or that. It would still wouldn't work in the court of law if the classification that they have filed with is the same, exact same classification. So there could be a lot of technicalities in this area of trademark. Um, Copyrights, on the other hand, is complicated. If you have not actually put your work somewhere, or you don't have a way of establishing whether or not you were the first one that produced it, or if it is being copied or you copied it, that kind of a situation might create a lot of problems. So it is a good idea to use third-party depositories, and they would charge you a very small fee and keep that under, the index that they have for establishing the time of receipt of the original work, with your name and time and date stamp is actually put in there. So copyrights, it's a good idea to do that if you can keep doing it. But those who are, writers who write articles like every day, or they're very frequent writers of uh, of a lot of articles or blogs on regular basis, it is very hard to put your work on third parties platform all the time. So what you do is that you have to, at the time of uploading it, you have to put it in the code, and then you can actually cache that page, or put that the cached cage in on platforms like Wayback Machine, for example, um, which I'm sure you know of. You know of Wayback Machine, Justin?
A little bit.
Okay, so in the Wayback Machine, you can actually, and especially if you're putting your writings somewhere on the internet, it's easy to get copied. So, what type of precautions would you take to protect your copyrighted work? I'm just um, thinking, thinking out loud. Generally, how would you preserve the originality of it, or what would make you contest it in case there is somebody who copied it and you have to go after court of law?
I'm not. I'm not too sure.
One of the easiest thing that you may want to do, and this would go a long way if you don't want a lot of trouble or something that choose an amount. Now they want money. Okay. This used to be, okay, this is a site that you may want to look up. It's called archive.org backslash web backslash. You can just remember this. Um, and here is what you will get to see. Now, I had a website, it's called bevocalize.com. This was a technology we designed about 10, 12 years ago. And we had the website. Um, and I just want to make sure that I'm able to collect. But this website does not exist anymore. So, used to be there, but now if I want to get a page from it, was my intellectual work, but somebody copied it, for instance, and I don't have anything available for me right now to produce as an evidence, then I will look for the cached pages that are still out there somewhere. I cannot bank on Google, may have just thrown it out of its system. So I will ask archive.com to see if they have a copy of it. So I would say be vocalized. I'm going to write the website and ask it to look for what happened. Okay. So when I wrote bevocalize.com, I looked at 2009, 2010. All these vertical bars are telling me that it has copies of these pages somewhere there. So in 2010, I want to look for those pages, and this is the calendar that opens up. There is one collection that they made on 10th of February 2010. So let me try to get to that page. When I click on it, I should be able to see it. Now, why it is there is because it is archived or it is captured. So at least my HTML code is there, pictures are gone, but I could see a little bit of it. Okay. So this is the page I can see. And if there is a page that I want archived or I want it to be collected by archives.org, and if it is my original work, I'm going to copy the URL and ask Wayback Machine to archive it. All I have to do is simply go to collections, or I think now they want money. You can sign up, and once you log in, it will give you the opportunity to put that link which has your original work to be set in there as uh, or instructing it to collect that page and archive it. And that would be your digital evidence and your date and time stamped work that later you can claim to be present or has been published at certain date. And it is not coming from your own archive. It is actually now on a third party platform, which is what we are accessing, right? So one of the things that you can do with Wayback Machine, okay, and collect and make sure that your copyrights remain intact. Okay. Type squatting, cyber squatting. Okay. Okay. Types of train. Forgot what's the difference. Type squatting versus cyber squatting. Let me go to the book here. Here it is. So let me just use the book for the type of trademark infringement. Okay. Let's look at that. So in the, you know that I don't know how far the domain names are trademarkable, because the domain names right now under the current laws, it has become a very tricky situation to establish or to call the domain name um, as your own trademark. It is not even copyrights. What it is an intellectual property that can be bought and sold. So it has a value to it. Um, but at the same time, the domain names are actually, even if you pay for it by buying it from the registrants, uh, you can own it for, or it is considered a leased domain. It does not, you don't become an owner of it for life. And in trademark situation, you do become owner for life, as long as you're using it. If you're not using it, then it comes back in the public domain, or the registrant again would be able to reclaim it. Okay. So domain name is, is kind of tricky, but for now, the trademark, for instance, I give you an example. If the trademark for Cisco systems is Cisco is CISCO, Cisco systems. And Cisco makes routers and switches and the network equipment. And I'm saying it from my experience. There was a website which was selling, let's say, Cisco parts, but it is not the Cisco systems as the original owner of that part, of those parts. But the domain Cisco number 4 and less.com is acquired by somebody, or somebody paid for it and registered it in their name. So Cisco came back and sued them and claimed that domain name only because the word Cisco was part of it. And in the eyes of consumer, could have caused that confusion, and it would result in diminishing the goodwill or blurring the goodwill. So, from that point of view, the trademark was infringed, and the claim is rightly contested by the owner of Cisco Systems, and so they got the result was they got a decision in their favor. And the same thing happens with domain names these days. What used to be a high value domain name that one can acquire, and one can keep accumulating them and then start to sell them as if they're actually the vendors of domain names alone, and they would end up selling it to the owners of the original manufacturers, or owners of that the word trademarks, and they would just keep selling them and make money out of. So that has become a practice that now falls under the trademark infringement. So let's look at the domains. Generally speaking, the domain name trademark infringement, and for now we just consider trademark as part of the as the domains being part of the trademarks. Okay. So one of the things that happens in the domain site is typo squatting. Um, um, okay. Okay, typo squatting is, typo squatting is when you are writing something which makes it look similar to the original vendor site. So if we have something like paypal.com.ca dot something, it is typo squatting. Means that you got it as a domain name, because the domain name, in you can get dot coms also. You can put dashes also between words. So it sort of gives a picture as if it is coming from the original vendor when it is not. So, typo squatting is buying those registered names legally, yet they are trademark infringement, because they have a way of distorting or somewhat making very subtle changes in how it is phrased in the domain name. So that is typo squatting. Cyber squatting, something that contains the domain name of someone that you have registered and then you're trying to sell it. So squatting means you're sitting on those domain names that have the in the wordings of a domain name, the names of famous brands or famous, uh, l- you know, um, manufacturers or vendors of those goods and services. So the example like Cisco for Less is one of the ways in which cyber squatting might take place. Pagejacking is, when you're getting your phishing scams coming in your email, and when you click on the link and it takes you a page which looks similar to or exactly same as the original owner of those pages. Like it happens a lot for financial institutions like banks, for instance, like TD Bank, for example, has pagejacking, a lot of pagejacking. PayPal has a lot of pagejacking. You know that is the trademark infringement. You've got linking, which I told you is just linking something to another website or images or multimedia coming or displaying on somebody's website when it is actually linked outside of that domain. If you click on that link, you'll see it's taken you to another page which looks similar to the original, and is actually, when you look at the address bar, you not only see a domain that is changed, but you also see a page which is now linked from the original website to this new one, which is a fraudulent website. So that is linking. Framing, I told you about. Anything that is happening in the real time somewhere else, it can be displayed at the same time when changes happen on the original website. It starts to affect what you have placed within the frame, as if the event or change or the content display is happening simultaneously on both sides. So it is as if it is mapped directly on into the frame or demarcation of that box that displays on the content pages. Right? Then meta tags and hidden tags are also infringement. Like one can say that certain keywords which are more popular, that is used by your competitor, or say not the competitors, but somebody whose work you're infringing, you're copying it exactly as it is coming from their website. When you are copying the coding, which is not the display side of it, but the coding side, one of which is the keywords, how they are placed, how they are, because it is a strategic move, and strategically for SEO reasons, for marketing reasons, and for the reason of why the Google keeps pointing to their website in the result pages. Um, and it's because certain keywords or the way the code is set is recognized by Google as being more popular, and you copy it exactly and place it in tags, as in keyword tags, for example, and others also. So this is meta tags and hidden text that otherwise would be recognized by Google, and because of that, you're copying it and putting it on your website. Then we talk about the trademark dilution or weakening of a trademark. This is the main thing that establishes how much of a loss has occurred to the original manufacturer or the original vendor who's selling the original products, because now the consumer is confused to consider low quality of work that is a copy on another website, yet it is compromising the quality or the branding of that manufactured goods. So you're not only a cause for losing that market or that business for the original site or the original manufacturer, but you are also diluting the goodwill or the recognition of that brand because of the low quality that you are producing in comparison. So you're diluting, effectively, you're diluting somebody's trademark. In the trademark dilution, there could be two things. One is blurring of trademark, the other is tarnishing it. Blurring means that you have um, is actually causing the um, trademark to be compromised for the quality that it stands for. And this happens when you are producing similar goods with a slight difference, but in the eyes of consumer, they could not differentiate much, and they are therefore causing a blurring, or you are causing a blurring of trademarks. But tarnishing is somewhat different. It is a direct infringement, which means you're producing exact copy of something which is tarnishing or giving a bad name to that brand, and that is a direct infringement and a cause of a higher level of damages that one can claim. And tarnishing is very high risk. Blurring is somewhat, in the middle. It has the middle grounds. But in both cases, there is a dilution of trademark. Dilution simply means losing the value of the trademark in the eyes of consumers, generally speaking. So that finishes up. Um, And then patents. Here is a chart on page 456. You can see that we have um, a chart that tells you what is considered patentable and what is not patentable. If you can look at it carefully, you don't need to to go through a lot of information in the book. You could simply make out what could be the differentiator. Because supposing in the exam, they would ask whether certain infringements are copyright infringements or trademark or patent related. So if you know the differentiation, especially between trademarks and patents, you need to have a clarity of mind to answer those questions. So in the chart, you can see the innovation. So on the left column, you can see what is the requirement of patents. Number one, the innovation is patentable subject matter, meaning if it is patentable or trademarkable or copyrightable. So what is patentable? Patentable new products as toys, appliances, tools, this and that. New process such as manufacturing. By the way, in order for you to establish a patents right, it's not something that you can simply produce as if you are the original producer of it. You have to actually file for it. Means that you have to know that it has got the uniqueness, or it has the ability to find no replacement in the general market, or there is no competitor for it, or if it is a newer technology or an innovation that can benefit someone or something. It cannot be something which is not a cause for benefit in general, or it is not something that is improving a process or creating a new design or anything that otherwise would be considered uh, as having a similarity with any other products. So it has to have that element of uniqueness. So what is patentable and what is not patentable? It is differentiating it and giving you some examples. New process such as manufacturing, mathematical algorithms or models process, or an industrial method or process. So if it is this statement that you read straight off, you can see that for first of all, for it to be patentable, it needs to be accepted by the patenting process. Number two is that it has to be a model, even in, say, processing or industrial method that benefits or improves something, or can be valued in terms of how it would improve a process, especially if it is in industry related. That needs to be established. Then you've got so here is a blurry line when you say new process such as manufacturing, not patentable versus patentable could be contested. Okay, based on the grounds that I just mentioned. If it's a software, software is patentable, but abstract, intellectual, or mental concepts are process. Software is patentable but at the same time, it is also got copy. It is also copyrightable. So this is where it can be a cause of concern for the court to know whether or not a copyrightable software is patentable or not. So you're going to fall back on what is considered as the points on the in this column, like 1, 2, 3, 4, 5, to know whether the software is patentable or it is copyrightable. So if the software is new, it's a novelty, then it is patentable. If it is an innovation, is inventive, then it is patentable. Okay. If it does not have any of these attributes 1 through 5, then software is not patentable, but it can be copyrightable. Business methods can be patentable. Again, they have to meet the test on the left-hand side. Um, and so this chart continues. We don't want to read through it, but just giving you an idea on how to figure out if it comes in the exam to know what can be patentable, what could be copyrightable, and what could be trademarkable. Okay. So we'll do chapter 36, which is online privacy, defamation, and spamming in the next class. And in the next class also, we have to do some examples, which is actually shown here in the slides. These are use cases, right? Like for instance, we are going to look at these paras to understand a situation where we have to determine the type of copyright infringements, whether it is direct infringement, vicarious, or if it is indirect infringement. So we're going to look at all of that and cover all these cases. We have 1, 2, 3, 4, 5, 6 cases that we have to finish because any of these will come in the exam and I have to finish it. Otherwise, you will get lost. I need that time. Plus, I have to do internet ethics. So I will have to do that with you, and hopefully, there'll be others present in the class so that, everybody could give their opinion as to what could be the best answer. Going to try to cover internet ethics, but it's not very complicated. It's just a general sense of what is involved in ethical concerns for researchers in terms of use of that information they're using in their research. So that we'll need about 15-20 minutes to do that. And so we have to really manage time. I have to manage time very carefully when we meet next. And whatever is the remnants of anything that's left out, we'll do it in the last class, which will be next week on Monday. It was not intended. I didn't want to spoil I just thought you'll get a sigh of relief when it gets finished on Friday, this day after, but I have to stretch it to Monday. So that having said, let's see each other on Friday then. And in the meantime, just let me know also if you're available on Monday because you may have, or any one of you may have planned something considering the last class was on Friday. So at least I'll get to know if you're able to make it or not. So any questions, Justin, I can answer for you, or any questions on copyrights or trademarks in particular.
No, that was great.
All right.
Appreciate the overview. And
So
I'll
a
be
lot of,
Monday.
all right. Okay, good. Thank you so much for coming.
Yeah.
And, I was able to, you know, I didn't have to talk to the machine. So I'll see you
That's
day
always
after.
nice.
Thanks. Take care. Have a nice evening. Bye bye.
You too. Take care. Good night.
Take care. Bye bye. Good night.